Hi, everyone. Good evening. Carl Steinbeck here from San Antonio, Texas, going to talk tonight about the motion for new trial for Kouri Richins, that Utah murder case where she was convicted of first-degree murder and other supportive type crimes involving the death of her husband. And so what I want to do is get right to the motion and present that here. Stand by. Let me pull it up on the screen. Hope you all have a good weekend. It's about to end here. So this is in the 3rd Judicial District there in Summit County, Utah. You see this filed by the Nestor Lewis PLLC law firm with Wendy Lewis and Catherine Nestor. Both these are former federal public defenders. And Ms. Nestor was a chief public defender of a certain office she was out of. And then they also have this Alex Ramos. We've seen him previously. So this is before Judge Richard Mrazek. And he was a guy that I thought did a terrific job from the bench and making sure this trial ran along. And he's very sharp on the law. And I thought he ruled very appropriately. So let's see what we have here. So they're deciding the rules or procedure to request a new trial. They're saying there's due to irregularities in the trial proceedings and cumulative error. And then they attach some video clips and documents to support the request. For statement of facts, they go through the different counts. It goes through the history on the dates, the preliminary hearing, and the trial. She shows that Kouri Richins was found guilty. 1 count criminal homicide, aggravated murder, and 1 count of attempted criminal homicide, aggravated murder. 2 counts of insurance fraud and 1 count of forgery. So that's what she was convicted of. Everything she was convicted of, that she was charged with. And then it says here, according to Rule 24, the court may grant a new trial in the interest of justice if there's any error or impropriety which had a substantial adverse effect upon the rights of the party. So that's a pretty substantial burden there for the person filing this motion. A new trial is not necessary, however, when the error was sufficiently inconsequential that courts conclude there's no reasonably likelihood that the error affected the outcome of the proceedings. So unless there's some kind of error that contaminated the proceedings and would preclude her from getting a fair trial, then the convictions will stand. So in other words, a new trial is not merited where an error is harmless. And then it goes on to cite here another Utah case. A motion for a new trial is generally permitted for correcting errors made in the trial court or for reviewing a conviction obtained by unfair or unlawful methods. Did any of that happen here in her trial? And then they say there's 3 grounds that Ms. Richins' conviction should be vacated and a new trial granted for the following reasons: the court's clear demonstration of bias in favor of the state displayed before the jury to deprive Ms. Richins of a fair trial. 2, the state's repeated reliance on other crimes, wrongs, or bad acts and the omission of evidence proving Ms. Richins committed wide-ranging financial crimes over numerous years in several general categories, went far beyond the court's pretrial rulings, and also violated rules of the 400 rules, which is 401 and through 403. It's like relevancy, admissions of relevant evidence, prejudicial evidence that should be excluded, and then 404B is prior uncharged bad acts. And then the those resulted in substantial undue prejudice, denying Ms. Richins a fair trial. And then number 3 is cumulative error. So really, they only got 2 main things, and then a catch-all kitchen sink type of claim of error. So what they say here now is that the court's repeated assistance to the prosecution and disparate treatment of defense counsel before the jury denied Ms. Richins her right to a fair trial. So having seen this trial, folks, I can tell you that this judge had unbelievable amount of patience towards these defense attorneys, which were just very, how should I say, very much not very effective in their advocacy. They did not come across sharp, clean, and crisp, and they sort of stumbled through different portions of their case. They seemed to delay a lot of stuff, just throw out a lot of questions that were really just gobbling up time to make it look like they had some kind of cross-examination when they really had no good points to make. So They didn't have a whole lot to work with. So what they're saying here, though, is that throughout the trial, the court repeatedly interrupted defense counsel, corrected counsel in ways that suggested to the jury that counsel was mishandling witnesses, assisted the prosecution with its objections, and curtailed defense objections. Okay, well, because you're throwing up a lot of nonsense, things that you know and should expect to get denied on or overruled. And it says on at least one occasion, the courts did so in a manner that made it clear to the jury that they was offended by the defense counsel. This mixed conduct created an appearance of bias against Ms. Richins and in favor of the prosecution, depriving Ms. Richins of a fair trial. Pursuant to the 14th Amendment of the U.S. Constitution and Article 12 of the Utah Constitution, the defendant has the right to an impartial judge. In the presence of a judge who is not impartial constitutes a structural defect in the trial mechanism that violates the Constitution and requires reversal. And it goes on to talk about how a cardinal principle of our legal system is that the courts of justice act upon the belief that if guilty, a party will be found after a fair trial. If both ends and means of the trial must be fair, or no matter how abhorrent the offense charge or how evident of guilt, the accused has an absolute constitutional right to a fair trial before an impartial judge and unprejudiced jury. And it goes on to cite another case from New Jersey from 1970. It says courts have long recognized that trial judges' comments and actions carry great deal of influence with the jury. The influence of a trial judge on the jury is necessarily and properly of great weight, and in his lightest word or intimation is received with deference and may prove controlling. A trial judge's position before a jury is overpowering. His position makes a slightest action of great weight with the jury. And then they go on to say in this matter, the court engaged in repeated conduct that denigrated defense counsel both in and outside the presence of the jury. The court was often impatient, critical, and hostile towards defense and only defense. The court frequently interrupted defense counsel by telling them to pause or focus. Never was the state told to focus. Well, you guys weren't focused. You guys weren't prepared well during much of it. During the day before the trial, the court interrupted the defense counsel on 24 separate occasions while only interrupting the state 13 times. Okay, I can tell you right now, by trying to do a numbers count game, this is so weak, extremely weak. They're just trying to throw stuff against the wall, hoping something sticks. This normally may not show bias, but the interruption of defense counsel was curt, cutting off statements and arguments while interruptions of the prosecution were followed by apologies, or often to help with logistical issues or aid them with objections. This pattern followed throughout the trial. On day one alone, the court interrupted the defense 36 times, as opposed to interrupting the prosecution 20 times. Well, the prosecution was really sharp, very efficient and effective in their presentation of evidence, and the defense were stumbling and bumbling much of the time. So what do you expect? Interruptions to the prosecution were generally clarifying, accommodating, or logistical. For example, on day one, the court interrupts the state to help clarify their argument and redirect the state's argument into the court's framing. And then on another page, the court interrupts the state, but only to confirm a fact helpful to resolve an issue. Then again, the court interrupts the state to inform them the information is helpful. To the contrary, when interrupting the defense, it uses language that doesn't track. Also says, move on, you're jumping the gun. And it also says, I think it's premature. This is only one day of trial. A full review of the trial transcript demonstrates that this is desperate treatment of the defense. It was persistent, prejudicial, and well outside the bounds of neutral courtroom management and administration. So they're really making a personal attack on the judge, that he was out of control, really was playing extreme favorites to the prosecution, and very much trying to punish the defense and stigmatize the defendant in the process. In addition to speaking in a disparaging and condescending manner to the no, he wasn't doing that. He had a lot of respectful tone, and he was never talking down to the defense. He would question them at times on what they're doing, and he did so in a respectful manner. He never lost his cool. Times he thought he should have lost his cool, he didn't. So the court would also reframe arguments in a way to help the prosecution. One strong example of this took place on day 10 of the trial when the defense was attempting to elicit testimony of the victim's prior use of pain pills. Not only did the court interrupt the defense, but it also continuously rephrased the argument, insisting that defense counsel use the term illicit street drugs, defining such drugs in a way that does not include prescription pain pills. During this argument, the court did more than frame the issue in terms of favorable to the state. It affirmatively accused Ms. Nestor of knowingly misusing the court's chosen definition, a definition unsupported by any expert testimony or evidentiary basis, and instead supplied by the court itself. Okay, so this had to do with what constitutes illegal street drug, illicit street drugs. And so, okay, so illicit street drugs, some people may say it includes prescriptions, painkillers. If you don't have the prescription for it, is that really illicit? If you're going to say it's in a way that does not include prescription pain pills to try to help the prosecution, then that's like a harmless thing. I don't see the big point here. They got in examples of things that they were trying to get out about Kouri Richins' husband. Other examples of the court speaking down to defense counsel are noted at attachment A, where the court accused Ms. Lewis of intentionally ignoring what the court is saying and informing the defense as an answer to the objection that they can call all their own witnesses in the case, thereby burden shifting. Attachment shows the court did not simply rule on Ms. Nestor's objection to relevance, but commented on the objection in an extremely disparaging and condescending manner, saying, "You don't see the relevance?" And then it later on goes on to say the court was extremely condescending toward Ms. Nestor's request for continuing objection. I don't recall that at all. And the court shut down an objection by Ms. Lewis during closing, interrupting her in the process and strongly saying, "Please be seated." This was particularly prejudicial to the defendant as it was in front of the jury, indicating the court was angry with the defense and making it clear that objections during closing would not be tolerated. The state then went on to make several objectionable statements during closing, leaving the defense with no remedy in front of the jury. This all sounds like a bunch of whining. It doesn't sound like anything of substance. Goes on to cite a Utah Court of Appeals case that said that judges must be particularly cautious with their treatment of counsel in front of jury, and a judge's conduct before jury is critically important because it directly implicates a defendant's constitutional right. And it says constructional right, should be constitutional right to a fair trial. When the judge abandons impartiality, the resulting bias can affect the entire proceeding, violate due process, and require reversal of conviction in regards to strength of the evidence. Courts have long recognized that trial judges' comments and actions carry a great deal of influence with the jury. And it goes on to talk about, in order to ensure a fair outcome and maintain public confidence in the legal system, it's paramount that the trial judge maintain the appearance of impartiality, especially in jury. Think of all this and then think about the Karen Reed trial, those of you that followed it. So this judge was very, very much assured them a fair trial, the defense. So I don't see any of this having any traction. A full review of the trial transcript clearly shows that the trial court was demeaning and condescending to defense counsel, and in contrast was friendly to the prosecution, often helping them both of their objections and the framing of the arguments. Much of this conduct took place in front of the jury. I do remember that the judge would sometimes talk about, well, it's not admissible for this, but are you trying to do it for this reason? So some of that, he was helping both sides. It wasn't just a one-sided thing. And not all judges do that. But to say he overstepped his bounds, this is nowhere close. Trial judges sit high above everyone else in the courtroom. They preside and they decide. They welcome and protect the jurors, accommodate their schedules, make sure they have everything they need. The influence of the trial judge on the jury is necessarily and properly of great weight. Yeah, we've already seen that. And its lightest word or intimidation is received with deference and may prove controlling. Okay, they've cited this a couple times now. The jury looked up to the trial judge, laughed at his jokes, and engaged favorably with him throughout the trial. A full review of the record makes it clear that the court let it be known to the jury that it favored counsel for the state in their position. Yeah, you're not coming up with any really specifics here. This is really just broad brush allegations. So they know this is a loser argument. The prosecution ran a tight ship. Bloodworth did an awesome job. When the prosecution raised concerns, the court often accepted, clarified, or helped frame them. When the defense raised concerns, the court more often responded with interruption, correction, skepticism, or curt commands, move on. Well, because they're doing a lot of sloppy advocacy, I think is the reason for that wasn't because they were doing as good of a job presenting evidence as the prosecution was. The defense was fumbling through this quite a bit. And there was a lot of complaints in the commentary of how these defense counsel were just terrible to listen to. It was very painful to watch the defense in action. So the judge had extreme patience with them, in my opinion. In addition to the court's treatment of counsel, a full review of the trial transcript shows multiple instances where the court suggests that defense objections could be resolved by the defense calling their own witnesses, thereby shifting the burden and instructing them to put on a defense. The rule with respect to the scope of cross-examinations continues to be that it is limited to the subject matter of the examination in chief, or in more modern parlance, the limited scope of direct examination. While enforcement of this rule is generally within the trial court's discretion, in a close case, the rule must not be so strictly applied to deprive defense an opportunity to present to the jury a vital element of the defense, here the government inducement, an element of entrapment defense on which the accused had a burden of proof. In a particularly heated debate with the defense counsel regarding argument over the state's request to put on additional statements by Carmen Lauber after she had already taken the stand, the court told the defense that they should recall Ms. Lauber in their case if they wanted to question her on these statements that the state did not put in her testimony. At times, the court went so far as to tell the defense to put the defendant on the stand rather than allowing certain lines of questioning. Well, if they can't get certain evidence in because the rules of evidence did not allow it, he's saying if you want to bring this in, the only other way you can do it is to recall Carmen. So he's helping both sides frame their issues. They're trying to say, hey, you're denying me a trial. Hey, you're not letting me get this evidence in. And so he's telling them how, if they want to do it, he'll allow that to happen. So that's not pushing the burden on the defense to come up to present a defense when there's no requirement to present a defense. Think about it. In American justice system, only the prosecution has a burden to present evidence. The defense has no burden whatsoever. They could just sit there and not saying the whole time if they wanted. So the judge was not forcing the defense to present evidence. He was just describing how, if you want to get this in, that's one of the ways you could do it. They're saying the court may not abandon the rule of neutral arbiter and assume the role of advocate for one side. He wasn't doing that. Let me talk about Utah courts. Judicial comments or conduct suggesting favoritism can undermine the public confidence or deprive the accused of a fair trial. I found nothing unfair that this judge did. He called it straight down the middle. He was not favoring one side or the other. When the court supplied objections for the prosecution, then sustained those objections, the court did more than manage the proceedings. It communicated to the jury that the state's position had the court's approval and that the defense questioning warranted judicial intervention even when the prosecution itself did not object. Okay, where are these examples? Nestor, where are these examples? You've seen this pervaded the entire trial. Where are these examples? Give the exact quote. Show the exact reference to the trial transcript. That appearance of alignment with the prosecution is precisely the type of conduct that it can affect the fairness of the trial and requires a new trial. Overall, based on the court's conduct, it appeared that the defendant was not facing a single adversary, but was rather had to bear the consequence of a judge who acted at times as a second adversary who appeared to disbelieve either defense counsel or defense witness. Well, defense counsel were not very credible. And this had a real a real, how should I say, it was a very disjointed, sloppy defense. And they seem like they're in over their heads. Yeah. The only thing prejudicial to your in conduct was your conduct as lawyers, I would say. You were supposed to be the zealous defender of her, and you did not come across clean and polished. Either one of you. And then they say that basically because they're claiming bias on part of the judge should reassign the consideration motion to another judge. And so they're questioning his impartiality. So they're saying he has a personal bias or prejudice concerning a party or party's lawyer. So yeah, this is not going to be heard by Judge Mrazek at all, and that's fine. Again, they're trying to show the basis why he should not be deciding the outcome of this motion for new trial. Given the apparent objective bias discussed, the actual conflict of interest created by the allegations of the court's bias and need to ensure due process, disqualification from ruling on this motion is warranted. Yeah, that's fine. No problem. You're going to say the judge was outside the bounds of being neutral, then fine. That would be not fair for him to have to decide, no, I was neutral. Let an outside judge look at the record and determine whether any of this has any merit. Okay, the next thing they allege, second prong, is that the state's repeated reliance on other crimes, wrongs, bad acts, and the omission of evidence proving Ms. Richins committed wide-ranging financial crimes over numerous years in several categories went far beyond the court's pretrial rulings and violated the rules of relevance and prejudicial evidence that should be admitted, and including 404B, prior bad acts, and it resulted in a substantial undue prejudice in denying Richins a fair trial. So prior to the defense trial, the defense filed motions limiting seeking to exclude from trial evidence over 30 other crimes, wrongs, or bad acts connected to Ms. Richins. So it doesn't have to be a crime itself. It could just be anything that's makes her look bad. And dealing with her business or financial dealings over a period of several years. In January, the court held a hearing to determine to what extent all of Ms. Richins' alleged financial deeds spanning years before Eric Richins' death could be admitted to trial. The court gave the state some general guardrails, attempting to avoid the 404B issues at trial. At trial, the state went far beyond the court's pretrial rulings and introduced testimony of Chelsea Barney and Brooke Carrington, going into great detail about numerous financial misdeeds. And they had those attachments there. Ms. Carrington spent an entire day on the stand testifying about bounced checks, false statements, misleading communication with lenders, mismanagement of business affairs, sloppy accounting, improper tax accounting, and on and on. Ms. Barney testified how she lost her life savings in her home when Ms. Richins mishandled real estate transactions for her and allegedly lied about it. The defense objected to all the state's attempts to inject allegations of financial business fraud or dishonesty in the trial, despite the court's pretrial rulings, and each and every objection was overruled by the court. The very beginning of the state's closing argument specifically referred to Ms. Richins as taking out a HELOC without her husband knowing about it for years before he died. 7 pages of the state's closing argument focused on the testimony of Carrington and Barney. And then it says Ms. Richins' case is similar to the case of the South Carolina versus Richard Murdo, of all people. Imagine that. Where the Supreme Court held that it was overly prejudicial to allow the state, under the guise of proving motive, to introduce vast amounts of evidence showing financial misdeeds of the defendant, spending years of time prior to the murders of his family. Like Murdo, and Ms. Richins was denied a fair trial due to undue prejudice of financial wrongdoings permeating her trial. The only appropriate remedy is new trial. Well, first of all, the court in Murdo overturned that conviction because of the actions of the clerk of court, tampering with the jury. What we have here, they did cite that there was a concern with the state overdoing it on the financial crimes by Murdo. They did not actually rule on that, though, because they found that a new trial was warranted just based on the obstruction of justice by the clerk of court. So to have to bring this case up here, I mean, really, that's sort of a stretch. And it's not controlling law anyway. So South Carolina law, that was what we would call a persuasive authority, not controlling authority. So even if it was exactly on point, it's not controlling and binding this court here in Utah. The financial evidence that was brought out in Murdo, I remember I was shocked. They kept on going on and on and on, all these details being brought up. Yeah, they brought up some of that on Kouri Richins, but it showed how her financial situation kept kind of getting worse and worse. And it directly ties into how she needed to kill in order to fund that monster house on the swamp. So the mansion on the swamp. So it all tied in beautifully. He didn't spend too much time on it. And I'm talking about Bloodworth. So that's going to be a denied point right there. And then the third one is cumulative error doctrine. It says here a conviction should be reversed when two or more errors occurred. Each error standing alone has conceivable potential for harm, and the cumulative effect of those errors undermines the court's confidence that a fair trial was had. A court's confidence is more likely to be shaken when the errors work together in a precarious manner as to cause more prejudice than the mere sum of the individual errors. The cumulative error doctrine applies when a single error may not constitute grounds for reversal, but many errors, when taken collectively, do. So here you have it. This it's only 14 pages, including the header, introduction, and the end. So this is really not a whole lot there to go on. Yeah, let me show you. So instead of like showing excerpts, hold on a second. I want to show an attachment here. Stand by, please. Okay, here it is. Okay, check this out here. They just attached Exhibit C, the Brooke Carrington transcript. Check how many pages this is. Shows down here 325 pages. See right there? And it's a partial transcript. So here we see for the plaintiff, Brad Bloodworth, the rest of part of his team. For the defendant, there are those three attorneys. And then you have all of this. So the court's going to read through all of this, through her testimony. So it's very much shown her financial status, and her financial status was what motivated her to commit the murder. So I don't think in any way, shape, or form the state went overboard on going through these detailed records. We heard about all these bounced checks and how she was trying to cover them. And it was really amazing how she's able to stay afloat. And it's really shocking that she could get a loan through these private lenders, because no bank would have loaned her money with her situation like this. But they were charging super high interest rates, and they had collateral on the property. So they're figuring, hey, we're going to, as long as we're making $110,000 in processing fees for the note that they had on this mansion. Think about $110,000 just just for a loan fee, this private loan fee. Then the interest rate was super high. I can't remember the details of it, but anyway, they're not highlighting any parts that they're saying are inappropriately detailed. They're trying to say, well, it's a cumulative nature of it, but I just don't see it. Because all this painted the exact financial distress that she had. And so then there's one other attachment. Let me see if I want to go into that at all. Stand by. Oh, they have then the testimony of Chelsea Barney, 10 pages of the transcript, okay? 10 pages of the direct testimony of her. Remember, that was the one that she thought she bought a home from Kouri. I mean, that made Kouri look really bad, right? But in the end, to be able to hide the ball, defense hiding the ball on how bad she was off financially, it would have been a miscarriage of justice. It would have denied the state a fair trial. Sherry Bolts, yeah, Kouri cooked the books in order to get some of these loans too. I mean, it's one of her best friends she lied to and made her think that she bought a house when she didn't at all. And the down payment she made was just basically for rent. Fletcher, if the state rules against Kouri on this motion, how could it affect her appeal? The state doesn't rule. The judge does. I guess normally when you say the state, a state of Utah, for example, versus Kouri. So the state won't rule, but the judge who works for the state will rule. So I expect him to rule against her. And let's go on to the next step of appeal. It'll go up to the next Court of Appeals. And then it should go to the Supreme Court after that. But they may not be the ones that do the appellate work. I'd be surprised if they do the appellate work, just like we have with Donna Adelson. I don't think trial attorneys make good appellate attorneys, especially on the ones that they represented the defendant at the trial and lost. Lisa, you're saying that female defense lawyers kept yelling at witnesses and Kouri kept pulling faces. Both behaviors worked against themselves. Yeah, remember all those faces that Kouri was making? Laughing and smiling at different times when it was totally inappropriate. It's always inappropriate in a murder case to be laughing and smiling if you're a defendant. Okay, here we have 1940 saying, I went back and watched some of the portions of the trial they referenced and actually disproves their claims. Okay, good to know. Roseanne's interested in Bloodworth's response to this fraudulent motion. Yeah, I think that, this judge, he's professional. He's not going to take it personal that Nestor and Lewis are making these accusations against him. And if anything, he's happy he can wipe his hands of ruling on this motion, how to come up with something to strike it down. It's nothing but a headache dealing with this defense team. Brenda, does delay the civil and other criminal charges. Judge Mrazek was covering those as well. No, this should have no effect whatsoever. Separate case files, separate systems if it's civil versus criminal. I saw that they got over $1 million in court costs, attorney's fees, Nestor and Lewis. Kim Steinbeck, Nestor embarrassed herself when the judge asked her to sit down there in closing. Yeah, she did something inappropriate, right? So it wasn't like the judge was being out of line for doing that. Sarah Poole, Nestor's not very experienced. No, they have a lot of experience. They have a lot of experience, her and Lewis. But like I've said, experience does not equate to effective, skilled lawyering. You can try 300 cases to a jury, but you still may not be any good at it. Recovery Cat, yeah, you thought this was the most patient and professional judge. He never lost his cool. He always had a lot of patience. And Brenna, again, you're saying Nestor in the Robson case was just as bad. From what I saw of that, I only saw a few minutes here and there. I thought she was very deferential, very soft spoken in court. She did not like act like anything I saw her act like in this case here. Rich T. This judge actually coached both sides, which was amazing to watch. Yeah, he did. That's what I said. He wasn't playing favorites, picking on the defense. Citizen Kane, amazing that the conduct of a competent and fair judge can be called into question like this. I hope this gets slammed down forcefully. It'll get denied. There's no doubt in my mind it'll be denied. And on appeal, I don't see any good basis for appeal. Ineffective assistance of counsel would be the best basis for any appeal in a criminal case if you go to trial, but I don't see that in this case, that they were ineffective. So if you don't have a judge that keeps you from getting in the evidence you want in, he didn't deny him expert witnesses like we saw in Kieran Reed. He wasn't totally bolstering the prosecution repeatedly. So they have nothing here. Tracy, you're saying this judge was excellent. To see an unprepared one, check out the Shauna Brightigan trial judge. I think I saw that one. Yeah, it was very, very much a courtroom without much control, I recall. But yeah, these defense lawyers are very experienced, very experienced. Yeah, you're saying Nestor was incompetent in the Charlie Kirk proceedings. I haven't seen enough. I assume they've heard a lot of commentary in the public about the job they did in this case. Kate, you're saying Nestor was misrepresenting information to the court and the jury numerous times. This filing by them is wild. Judge Mrazek was so fair and patient, IMO. I agree. He was totally fair and patient. This train wreck defense could have been smacked around a lot by a lot of judges, and he was very patient, even-handed. Fletcher, you think the most damning evidence, the walk to dog letter, was excluded? Yeah, it was. Dagny, you're saying watch full trial, and Judge M was fantastic dealing with defense circus. He did extra to help them. That is true. Music to my soul. You're saying you loved the judge. You didn't necessarily agree with him on everything, but I thought he did an excellent job with this trial overall. He's like a real teacher to both these attorneys, and he did it fairly on both sides. Okay, so okay, Optimus, you're saying your parents went to church with Jared Brightigan's parents. Please cover the Brightigan murder trial when it begins. I hope to. I hope to do that. Yes. Yeah. Sure. You're saying defense had nothing to work with. It's tough to defend. And you had a great prosecution. Bloodworth did an awesome job. Robin Hood, you're saying, do I think the defense is trying to get a different judge in the financial trial? With this motion, the court will reassign. Judge Mrazek is so good. Nestor fears him. It could be. It could be. I don't know if it will work, but that could be a basis. I don't know if we know yet who the judges will be on those cases. Yes, 1940, you're saying their biggest question for the attorneys is this: why did Nestor and Lewis act as if they were in love with Kouri and make those statements that are elocution that they believe are 100%? Well, you want to show that you like your client, that they're enjoyable to work with, you really believe in their innocence, that kind of stuff. But I did think that sometimes they went beyond what they should have, where they start losing some credibility. So I covered this trial, so that's why I'm covering this motion for new trial. Several people asked me to cover this motion for new trial, so that's why I covered it here tonight. As a matter of fact, just because Nestor was loud and really argued and threw the temper tantrum doesn't mean she was treated unfair. I just didn't like their advocacy. It just didn't come across well. They did the best of their ability, but Linda Mon, would I ever go see Charlie Adelson in Sioux Falls? No, I would not, because A, he would not want to see me. B, he's represented by counsel, and I'm not licensed in Florida. He's in South Dakota, but he's there on a Florida case, so I'm not licensed in Florida. So I cannot represent him on anything. So what would I say to him? I mean, I'd have plenty to say, but in essence, he wouldn't listen to anything I say anyway. Here we have someone says they knew that they had a guilty lying client. No witness for her. She did not take the stand. I know it can't be held against her. It still looks bad. So next option is to slander the judge. Lasha, you're saying you're not saying that the judge was bad, but he wasn't shy about letting the Richins family know. I'm going to get her. Just wait and see. No, I don't see that at all. Kim Music, you're saying a financial trial is assigned to the judge currently. All right, so one more thing here. Fletcher, not having any defense witnesses left me convinced he had little to offer. Standard Poodle, what would I say to Charlie? Well, I mean, if I was his attorney, then I've talked enough about how when you have clients that are making bad decisions and you're looking at life sentence and there's other co-defendants that you could flip on, uncharged co-defendants or unknown criminal activity out there, that you have a client that can bring stuff forward. I've had clients like that before that I say, hey, do you know of any other criminal activity? There's not any co-defendants on your crime here, but if you know any other crime in the community that you could provide to the prosecution, and we could use that to help lessen your sentence, reduce your charges. And it's worked. So Charlie had no chance of getting an acquittal. I don't think he had any chance at all of even getting a hung jury, unless you had some knucklehead on the jury that wasn't following jury instructions, had some other agenda. Yeah, Linda Mon, I thought I couldn't flip Charlie and Wendy. No. I mean, that's the kind of thing I would do if I had a client like Charlie in a case like that here in Texas. I would tell him, hey, look, you're going down. You're going down on this case, and you got a good motivating factor for the state to cut your charges down significantly, just like they did. And I would say the example is what they did for Luis Rivera. And there's another example. I'd say, look what happened to Sigfredo. One was smart, the other one was stupid. Which one do you want to be? You want to cut a deal, or do you want to go roll the dice, go to trial, and then want to wind up like Sigfredo Garcia? Shilke, how long does it typically take for a decision to come back on the appeal? Well, this motion for new trial, we still need to have the prosecution provide their response, their rebuttal to this. And then these don't take as long, these motions for new trial, because it's at the trial court level. It might take a little bit longer because you're having a trial judge that's going to review it. That's not the trial judge that oversaw all the evidence. So it's going to take a little bit longer, a few months minimum after the prosecution submits their rebuttal. Catnip Farms, Nestor gaslights by always being offended and exasperated. She just did not come across as likable. So, all right, well, it's time to wrap this up now. I'm going to go ahead and sign off. So y'all have a great week, and I will perhaps cover something more on the question I'm being asked about this witness for the Karen Reed case, Colin Albert, who's in basic training, and whether he can be forced to undergo a deposition. Lisa Loney, you're asking, do you think I could do a deep dive into the financials of the Swamp House purchase? Curious how they made it work with the Department of Ecology, et cetera. Not a big fan of those kind of financial records. They're very boring, I think, for a jury, and I'm somewhat bored by that as well. I think it is fascinating, though, to think of all these hoops they had to jump through because the house was near some swamps, that they had to comply with all this remediation type thing to get approval to make it a livable house. So even though the house could have been completely finished, you can't get a certificate of occupancy, is what a lot of times they call it in states, to have people actually be allowed to live in the house. And so the reason why she was able to, she did not make it work. Somebody else did after she lost the house, but it takes a lot of time, takes a lot of money, it takes a lot of permits, a lot of experts, a lot of trucks with gravel and whatnot to fill in certain areas or clear out certain areas. And what folks have to do to preserve the swamp, you got those rules as well. So it's just nothing but a complete utter nightmare. I think that's why the house was probably abandoned by the previous owner, and as I understand, he killed himself in the house because it was such a nightmare to deal with. So think about that house, mansion on the swamp. The guy who tried to build it and couldn't finish it, he kills himself, and then Kouri Richins kills somebody else to try to swing it financially. So just very, very crazy outcomes here. So, all right, well, take care. Talk to you soon.